This is case number 22-179438. This is Earl Gray versus Elmhurst Homes Incorporated. Now, the matter is before the court set on for a hearing relative to entry of a default in this matter. Do I have Earl Gray on this matter? Say something if you're here, please.
Yes, I'm here.
All right, good morning to you, Mr. Gray. All right,
Morning.
Elmhurst Homes Incorporated, who do I have present on this Zoom at this time?
Hi, this is Betty Smith. I'm present.
All right, thank you, Ms. Smith. Ms. Smith, are you an attorney?
No, I'm not. I'm the employer.
All right. Well, you can't represent the corporation. The corporation has to be represented by an attorney. So is it the plan of Elmhurst Homes to get an attorney involved in this matter?
We can. I wasn't under the understanding that we had to have legal representation.
Yeah, any entity that's a corporation in the state of Michigan has to be represented by an attorney. And I entered this up for entry of a default. Let me see what's going on here. Just one moment. All right, so Mr. Gray, it sounds like the nature of your complaint is you're alleging discrimination. Is that correct?
Yes, sir.
Just one moment.
For discrimination and being wrongfully fired.
Yeah, it's starting to sound like the extent to which you're bringing this claim probably is more suited in the Wayne County Circuit Court. But still, with first things first, if you're going to get an attorney, ma'am, you're going to have to do so. I was going to have to do so in short order because this case has been going on since the date was first brought before this court. Since February of this year. So you would need an attorney before you would have the right to say anything. That the entity cannot be represented by anyone other than an attorney. So I'm going to give one last adjournment on this for that purpose. If there is no attorney involved in this matter when you reappear, then a court will have to enter a default and allow a judgment to be entered against Elmhurst, because it's like nobody's here for Elmhurst if you don't have a lawyer. So
No, we can get an attorney.
I'm going to go ahead and set this up for the 17th of January, 1/17/23, and I'm going to set that at 9:45 a.m. And you must have Elmhurst must be represented by counsel, otherwise they will have defaulted in this case. So it's going to be very important. All right. So
yes, sir.
1/17/23, 9:45 a.m. That's the next action date in this matter.
I'm sorry, what was the time again, Your Honor?
9:45 a.m. There will be a notice sent out in the mail to the address on West Chicago Boulevard, as well as to the address on Linwood. And it will have that time, date and time. But I just wanted you to hear it now. That's January the 17th of 2023 at 9:45 a.m.
Okay, and it's on Linwood, 12010 Linwood, Detroit.
Yeah, well, that's what I have. That's why I mentioned Linwood. I did mention the address with the street. That's all. That's what
Okay.
the notice you received the notice previously, correct?
Yes.
All right. The notice is going to come to that same address.
Okay.
But again, the big deal here is that there's got to be an attorney here. Otherwise, there's a default, and that default will result in judgment being issued against the defendant, Elmhurst Home. So make sure that you have an attorney present at that time.
We can have an attorney present, no problem.
We'll see you on that day. Good day to both of you.
Okay, thank you.
The court now calls case number 22-187279. This is Beaumont Health versus Raven Kathy. The matter is before the court, set on for the hearing. It looks like this may very well be the first hearing regarding this matter. The complaint alleges damage $327. Your appearance for Beaumont Health, please.
Thank you, Your Honor. Hal Burke, P69068, attorney for Beaumont Health on this case.
Thank you, Mr. Burke. Good morning to you, sir. I'm looking now for Raven Kathy. If you're on the Zoom, please say something at this time, ma'am. I'm looking for last name Kathy, C-A-F-F-E-E. First name Raven. Matter set on for 9:30. I have something I think that's offered as an answer. It says, I feel like I'm responsible for this bill because I was wrong for driving an uninsured car. But I'm going through things financially, have high bills. It's hard for me right now. I had to drive my car to get to work to pay my bills, and pay for my son's medicine. In conclusion, it says I have to pay this bill. I'm asking for a payment plan. It would be good if Miss Kathy was here. One more time, a person living on Edmore Street, Raven Kathy, if you want to assume, please say something at this time. All right, counsel, due notice was given. The defendant has stated her position regarding this matter. Counsel, go ahead. What's your desire at this time, sir? Your pleasure at this time, Mr. Burke. I'm sorry.
No problem. Thank you, Your Honor. Would you consider allowing us to file a dispositive motion? However, like I do with every case, and I know you and every judge, I believe, likes this, we're going to try to reach her again. And as you stated in her answer, it sounds like she wants to get on a payment plan. So I'd like time to file a motion. However, we will still attempt to resolve it directly with her.
All right. I guess that's one way to do it. I guess, at this point, she seems to be in default. I will give you time to try to resolve it in some other ways. So if you want to file a motion, whichever way you want to go, counsel.
How about, Your Honor, a default under the 7-day rule? And if we reach her before then, I will let the court know.
All right, I'll grant your petition for entry of a delayed entry of default in this matter. And I see that there's an effort to try to get worked out, because again, her statement is that she's not really contesting the debt. She just wants a payment plan. And I'm sure that some type of payment plan could be worked out to try to get this resolved. So I've granted your petition, and I'll receive the application for default under the 7-day.
Thank you, Your Honor. Have a great day.
All right, great day to you. The court now calls case number 22-189990. This is Angela Brown versus. The matter is before the court. Set for a statute of first hearing regarding this matter. All right. Do I have Angela Brown on this Zoom? Say something if you're here, ma'am.
Yes, I'm here, Angela Brown.
All right. Thank you, Ms. Brown. Good morning to you, ma'am.
Good morning.
Here on this Zoom. Say something if you're here, Ms. Hare.
I didn't understand what you said.
Yes, I'm here.
All right. Thank you, Ms. Hare, and good morning to you as well, ma'am.
Good morning.
Yeah. So it looks like, I think I told you all this the last time. In this case, it sounds like it belongs in the Wayne County Circuit Court. The plaintiff is saying that she has been blinded in one eye by some action that was taken in this case. This sounds like a matter that belongs in Circuit Court, rather than the limit of jurisdiction at $25,000. If injury has resulted in blindness, that would be an injury that would be significantly more than the court's jurisdiction here. So I think you need, go ahead. Who wants to talk? Go ahead, Ms. Sarah.
This is April Harris speaking. I have faxed over some documents of the police report. Also with the video footage from Angela while she received the eye injury. I want to know, did you receive any of that information as well?
I have not received anything that's in the nature of any kind of videos. I have.
Jelly, what happened?
And I also have a PPO on her.
Yeah, and again, if the plaintiff is alleging that you have caused injuries of such a grave nature as a loss of eye, then certainly that would be something that should be litigated in the Wayne County Circuit Court. Let me ask you, Ms. Brown, have you with a lawyer, have you tried to hire somebody to handle this case for you?
Yes, I was trying to contact a lawyer to handle my case.
All right, so again, I think that you need this case in circuit court to deal with the issues that you raised, because you're putting a limitation on the possible damages by being in the district court. And if there is an alleged injury, I know all of this is just allegations, but everything that comes before the court is an allegation. And then both sides get to communicate what their story is, and then a decision is made in that regard. So what I'm going to do is I'm going to sign an order transferring this matter to the Wayne County Circuit Court.
Thank you.
Because that's properly where this case belongs. And you're likely going to need to get a lawyer involved for you to properly advance your case, but that's going to be up to you. At least at this point, this case does not belong in the district court. So I'm gonna sign the order to transfer it to circuit court. Both of you
Okay, thank you.
transferring this matter to the Wayne County Circuit Court. All right.
Thank you.
You'll get that in the next few days. All right. Good day.
Okay, thank you. I'm off.
All right, this is case number, case number 2219-0674. This is Oakland Community College versus Katria Gildersleeve. The matter is before the court, set on for a status and scheduling conference. This is the first hearing regarding this matter. This case involves a claim for damages. Just one moment. And the amount of $22.96. Your appearance for Oakland Community College, please. I'm counsel for Oakland Community College. All right, I'm looking now for last name Gildersleeve.
Sorry, Your Honor, did you just call Oakland Community College?
Yes, sir.
Sorry, Your Honor, I was stuck on another Zoom. Matthew Kuipers on behalf of the plaintiff for that matter.
And your P number, if you will, for the record, Mr. Kuipers.
71348.
All right, thank you, Councilman. Good morning to you. I am looking for Miss Katria Gildersleeve regarding this matter. And Miss Gildersleeve, if you're anywhere on the Zoom, please say something at this time. All right, so Council, it looks like defendant has not appeared, although she did file an answer in this case. I see that the address that she provided is on Fall Street. That's the same address that we previously had. And so the notice went to that address. Have you spoken with her at all? Have you had any communication with the defendant in this matter?
Your Honor, I have not, and I don't see any indication in the file that she's made any contact with Velo Law Office regarding this, besides the answer that was filed.
All right, and I do have this set on for 9:30, and it is now 9:53. All right, Counsel, your pleasure at this time, sir.
Your Honor, based on the defendant's failure to appear, plaintiff would request that a default judgment be entered.
All right, under the circumstances where the defendant has failed to appear regarding this matter, the court will enter default against the defendant at this time, and will enter judgment on that default upon its presented. So ordered. Counsel, any paperwork that you might want to send in this regard, you can certainly email it. You want to take this email address down.
Yep.
That's going to be Carmen, C-A-R-M-E-N, Carmen.Banks, B-A-N-K-S. That's at 36districtcourt.org.
Okay.
36districtcourt.org.
Will do, Your Honor. And I also do have a 945 for Midland. I'm not sure if the defendant's here.
Okay, I will check that in just a moment. All right, I'm calling now case number 22-180-187. This is Midland Credit Management Incorporated versus Markeisha Hamilton. The matter is set before the court. Looks like this is set on for a review. Counsel, your appearance at this time.
Yes, Your Honor. Good morning. Matthew Kuipers on behalf of the plaintiff, P71348. And
Thank you, counsel. Let's see if I have Miss Markeisha Hamilton on the Zoom. If you're here, Miss Hamilton, say something at this time. I know that the last time that this matter was up, that there was some effort to discuss and try to resolve this matter. And that's why I set it on for review on today's date. Mr. Kuipers?
yes, Your Honor. So I'm happy to inform the court there was a agreement reached. A consent judgment was actually mailed to the defendant on October 4th, although we haven't received it back yet. But the agreement is the defendant is going to pay the sum of $1,533.94 at $50 per month. And per the notes I have here, it looks like there's already been $204 in payments made to date. So as soon as we get that back, we'll file it with the court.
All right. Sounds good. I'll indicate that the case has been resolved by a consent agreement that the court is awaiting an order. Thank you, counsel. Good day to you.
You as well, Judge. Thank you.
All right, the court now calls case number 22-186-708. This is LBNB Funding LLC versus Siobhan Clay. The matter is before the court, set on for a hearing on today's date. Looks like this may very well be the set for status conference, scheduling conference. This is the first hearing regarding this matter. I have received the answer and the claim indebtedness is $1,418.34. Your appearance for LBNB Funding at this time.
Good morning, Your Honor. Gavin Gray, P79819, the plaintiff, LVNB Funding.
Thank you, counsel, and good morning to you, sir.
Good morning.
I'm looking for Siobhan Clay. Ms. Clay, if you're here, say something at this time.
Good morning. I'm here.
All right. Good morning to you, Ms. Clay. All right. So I saw in your answer, Ms. Clay, that you indicated I agree that I owe this debt. But as time passed, I honestly forgot about it. All right. So have both sides had an opportunity to talk about this at all?
No, we have not, Your Honor. I actually, I don't see that we have an answer on our file system here.
There probably, well, it seems to me that maybe the copy was not populated to you or was not sent to you, but that's what I have. And it's dated the 19th of July of 2022. So let me just look at another part here.
I'm more than happy to go in a breakout room, Your Honor. Of course, looks like we, could work something out here.
Yeah, that sounds reasonable. It's worth talking about it. See if we can work something out and then come back into the courtroom. Ms. Clay, I'm going to put you in a breakout room with Mr. Gray, and Are you able to hear me? Sometimes I know my
Yeah.
voice tells. All right.
I can
And
hear
so,
you.
you guys have a chance to talk about it, and then you can come back in the courtroom and we'll figure out where to go from there. Hopefully you can get it worked out. So you'll get a notification from me right about now for breakout room number 1. There you
Okay.
go. I'll see. All right, the court calls case number 22-189165. This is Angelique Key versus Ella Ray Events. The matter is before the court, set on for a status and scheduling conference in this matter. The claim alleged before the court alleges damages of, looks like $2,000. And I've received the answer regarding.
I'm sorry, Judge. Your Honor. I'm sorry to interrupt. Can you hear me?
You should be interrupting me, so I'm not listening.
Oh, I apologize. I'm sorry. Go ahead. I'm sorry.
I'm looking for Miss Key at this time, Angelique Key.
Yes, I'm Angelique Key, Your Honor. I apologize, Your Honor.
Good morning to you. I'm looking for Ella Ray Events. If you're on this Zoom, say something at this time, Miss Events. All right, Miss Key, what's going on here, ma'am?
No, you had said 2,000. I actually made it for 7,000. And I'm sorry, Your Honor. I didn't mean to interrupt.
Yeah, your 7 looks like 2. That's why I said I'm looking at the documents that you filed. That's okay. I get you. All right, so let's see. What's going on?
Yeah.
All right, so I received the answer in well, that's not an answer. That sounds like that's from you. It looks like I got a letter that says, "Dear Your Honor, I'm here requested a court date upon scheduling. Could you please discard anything before September 8th due to my husband and I honeymoon." That came from you, Ms. Key?
Yeah, that was for June.
Yeah, that's okay. I just didn't know who that was coming from.
Yes, sir. Yes, sir, Your Honor.
That's on the side of the file where there's usually an answer. So have you received any kind of response from Ella K or?
No, Your Honor. I have not received anything, Your Honor.
Okay. So this is the name of the business, right? Ella Ray Events. Is that what that is?
Yes, that's correct, Your Honor. That's also the plaintiff's name as well.
Okay. But her name is not Events, is it?
No, her name is not Events. Her name is Suzette Terrell. I don't want to touch the phone. I don't want it to hang up. I don't want to touch the phone, Your Honor, to hang up. But it's Suzette Terrell.
Okay, gotcha. All right, so here is the reason that I'm asking those questions, of course, is because in your complaint, you know, you did not sue Miss Terrell. You sued Ella Ray's Events. You understand that, right?
Well, I'm sorry, Your Honor. I do have another paper here where her name was placed on it. Let me take a look real quick. I'm sorry.
I have papers with her name placed on it as well, but she's not a part of the complaint in this matter. You sued Ella Ray Events.
Yes, sir. If that's what's, yes, sir.
Yeah, I mean, it's, a lot of times what happens is sometimes people intend to just sue the business. Sometimes their intent is to sue the business and to sue the individual. I'm just saying here.
Yes, that's correct, sir.
Yeah, but you didn't sue the individual. That's the problem here. That's one of the concerns. All right, so it does not appear that Ella Ray Events has responded to the court's complaint. It also appears that previously there was a default that was presented to the court in this regard, and that defendant has yet not appeared. That is, the company has not appeared regarding this matter.
That's
Therefore,
correct, sir.
well, you don't have to tell me all that. I'm going through my order now. All right.
Okay. Just trying to be respectful. Just trying to be respectful.
Oh, no, you are respectful. There's nothing that you've done that's disrespectful. I would tell you that, trust me. I would tell you that. And it's not uncommon that people sometimes, especially dealing with Zoom, they don't, this whole electronic process sometimes can interfere with the exchange of communication as well.
Yes, yes.
Given that you have given the proper notice to Elevated Events, you're entitled to judgment by default at this time. And I will enter that judgment based upon your complaint. So judgment will enter for $7,000. You recall what the cost of the filing of your complaint was in this matter, ma'am?
It was, I want to say $175, Your Honor. That's what I want to say. I'm trying to look for it here. I do have the receipts. I'm sorry. And I want to say it was $185.
And I see on the service of process item that the service fee was $50, correct, ma'am?
It was only $50, Your Honor.
All right, so I'm entering judgment for $7,000 plus the court filing fee of $185 plus the $50 service fee. You'll get a copy of my my order in the mail in the next few days. You might end up with this matter. You might end up having to go back and try to, in some kind of way, include the individual, because sometimes you sue a business and sometimes
They'll change the name.
Not just change the name, you can track that, but even if they keep the name, if they ain't got no money, you don't have that to collect on. So that's a part of the challenge. So you'll get you'll get a copy of my judgment in the mail in the next few days, man. Good luck to you. I wish you all the best.
Okay. Do you mind if I ask you just a question?
No, you can't ask me any more questions. Go ahead, ma'am. I'm just messing with you.
Okay. Well, that's okay. I work for the court too, so Your Honor.
You're right. Do you work for this court?
No, I work for the probate court. So I'm right downtown with you right now if you're at home. I mean, if you're downtown. But the question that I have, I know that you can't give me legal advice. So when I do receive your judgment, what do I do after that?
You just don't. I can't give you legal advice, and you're absolutely correct about that.
Okay, well, that's okay. Listen, it's enough.
I didn't cut you off while you were asking your question. Don't you cut me off while I'm answering the question.
Okay,
So,
okay.
I can't give you legal advice, but the information, I can provide information. Information is that after you have a judgment for 21 days, you can use that judgment to enforce your rights. That means that you can file garnishments against bank accounts, against income, against property. You can ask for a court bailiff to seize property based upon the judgment that you have. All of those kinds of things you can subpoena individuals or subpoena the company to talk about the assets or give you evidence of their assets. If they don't respond to the subpoena, you could end up having the persons that run the company to show cause or be held in contempt of court. So there are a number of things that can be done. That's not really legal advice. That's just court process stuff. So
yes,
after 21 days, you have the right to start enforcing the judgment. And that is by garnishments or other methods to try and collect on your judgment. Right?
Okay. Well, thank you so much, Judge, Your Honor. I really appreciate that. And just to let you know, I think it's a delay in the voice. So sometimes it seems like I may be interjecting, but I'm not. But I really appreciate your time today.
I don't think it's all that much of a delay. Anybody else been interrupted? It's only been you interrupted. So. I'm just kidding with you.
You sound like my husband now.
I hear you loud and clear. All the best to you, okay? You'll get that.
Thank you so much. Happy holidays to you and your staff. Thank you so much. And just to tell you, April, she's been so good to me ever since I started calling. She's been helping me with the paperwork and everything. I really appreciate your staff. Thank you.
Thank you. Thank you. Appreciate that. All right, this is, we're back on the record regarding the suffix 6708. That is a case that involves LBNB funding versus Siobhan Clay. And welcome back to both of you. Counsel, go ahead and update me, sir.
We were able to come to an agreement, Your Honor. We're going to do a payment plan, or I should say a settlement, and enter that in the form of a consent judgment. I can overview this on the record and request permission to sign for her, or we can, send it to her, wait to, receive it, the consent judgment, and then file it with the court, however you'd like to proceed.
Yeah, I'd like to go ahead and put it on the record, and then you can email it to the court, and then I'll get it signed up right away, as long as Ms. Clay agrees with that. That's why I want to know terms, so that
Okay.
obviously the sign will be that which has the proper terms on. All right.
Okay. Yep. So we agreed to sell for an amount of $1,200. Is so long as Ms. Clay sticks to the payment plan here. The payment plan will start on January 20th. That'll be the first payment date, and the payment amount will be $100 a month. Each payment will be due on the 20th of every month thereafter. If she defaults on the payment plan, it will revert back to the full principal balance of $1,418.34, plus a $55 filing fee and a $99.50 service fee, for total costs of $154.50. And that would bring the total defaulted amount to $1,572.84. But again, so long as she sticks to the payment plan, she'll be paying $1,200 even. There is mutual release language in the consent judgment. So long as Ms. Clay sticks to the payment plan, we won't seek to garnish her bank account or any sort of monthly income or employment wages. We do reserve the right to garnish state taxes, but that doesn't look like it'll be an issue in this judgment here or this payment plan.
All right. Is that the agreement in this matter, Ms. Clay?
Yes, it is.
All right. So is it okay if counsel go ahead and send that to me with your initials as my consent? That means that you put it on the record. That's your agreement. And as long as it has those terms, then I will sign it based upon these terms. Is that okay with you, ma'am?
Yes.
Okay. All right. So counsel, you can go ahead and draw that up and send it to me. And again, Ms. Clay, if it says anything different from what the agreement is, I'm not going to sign it. But of course, it's very clear that it's going to say these terms because that's what you guys agreed to. You can send that, counsel, to Carmen.Banks. First name C-A-R-M-E-N, Carmen dot, last name Banks, B-A-N-K-S, at 36districtcourt.org.
Okay, thank you very much, Your Honor.
All right, I wish the two of you well. Happy holidays to you, and I will sign the order upon receiving it. Good day.
Thank you. Happy holidays to you too. Have a good evening.
All right, the court now calls 22-189-482. This is Grossbeck RX LLC versus Smart Transportation. The matter is before the court, set on for a status conference. Your appearance for Grossbeck, please.
Good morning, Your Honor. Mohammed Musa, P number 84297, on behalf of plaintiff Grossbeck.
Thank you, Mr. Musa. Good morning to you, sir. For Smart Transportation Council, your appearance, sir.
Good morning, Your Honor. Joseph Giacalone, P85482, appearing on behalf of defendant Smart.
Thank you, Mr. Giacalone, and good morning to you as well, sir. So it looks like you're just kind of getting started with this matter, or have you gotten some traction already? Somebody give me a status on where you might be in this regard.
So, Your Honor, this is the first hearing that we've had on this case. Previously, there was an October hearing that was scheduled, but was canceled the day of. So we're waiting in order to begin discovery. I do have a settlement demand from plaintiff that I've already taken to my clients, and I'm just waiting to hear back from them. Some of them are out of the office due to the holiday. So.
All right. So Mr. Musa, then it sounds like I'll put this in the normal course and set it over on a 60-day discovery order and set a pretrial right at the end of that period and see where things are at that time. You get it resolved, good. If not, you will have the opportunity to get some traction on this. So I'm going to go ahead and set it up for the 21st of February, and I will open discovery through that date. That's 2/21/23. Open discovery through that date, and the hearing on that date will be at 9:30 a.m. That will be a pretrial hearing. You will notice in the order that I'm going to send you that under paragraph number 6, it does allow you to file motions and set motions for hearing on the date of that pretrial. That's not a cutoff for filing motions, but it just gives the opportunity that if the parties come up with a dispositive or non-dispositive motion, you can file it and set it for hearing on that date, the 21st. And I will hear it on that date. One requirement is that you make sure the other party has at least 10 days notice of your motion. So that shortens the rules, of course, as you know, like as long as you file a motion dispositive or otherwise, set it for the 21st of February and make sure that the other party has 10 days notice of your petition. I will hear it on the 21st. And so you'll get that document in the mail in the next few days. All right. I wish you well. Best of the holidays to both of you.
Thank you, Your Honor. Happy holidays.
Happy holidays, Your Honor.
That is it for what I have.
Hi, I wanted to check in. My name is Raven Caffey.
Yeah, Miss Kathy, I called your case already and was looking for you, and you were not here. The attorney has indicated that he's going to reach out to you because your complaint in this matter, or your answer in this matter, says that you're just looking for a way to. I thought it said you were looking for a way to set up some type of partial payment agreement to get the state care. Is that what this is?
Yes, I was in the wrong courtroom.
Oh, okay, I got it. So it's going to Mr. Halbert indicated that he would reach out to you and contact you regarding this matter. And let me give you. I think you have it in the complaint, a number to Mr. Burke's office. You have that in front of you?
One second. I need to get a pen.
I can go ahead and give it to you. You know, so that you can contact.
I'm sorry.
I said I can give you his phone number so you can contact with him. But he indicated that he would reach out to you in an effort to try and get this worked out.
Okay.
So are you ready?
One second.
You know how to use your chat device on your phone?
Yes.
Okay. All right. So I'm going to send you the phone number for him. Okay.
Okay.
Send it in your chat. I see where you chatted me a little bit earlier as well. So yeah, let me give that to you.
Okay.
Okay, so there it is, and you'll want to reach out to him and tell him that you were in the wrong courtroom and that he told you to call that office and work out some type of arrangement because that's what he wants to do.
Okay.
Okay. All right. I
Okay.
wish
Thank you.
If in the process you have any problems along the way, that I'm here. I'm here every day, Monday through Friday. You could zoom back into this courtroom and bring it to my attention. Make sure you have your case number, and we'll try to work at some of the logistics, okay?
Okay, thank you.
All right, all the best to you. Happy holidays.
Same to you.
All right, Madam Reporter, appreciate you this morning. I think